A green card, officially known as a permanent resident card, allows a foreign national to live and work permanently in the United States. For millions of people around the world, becoming a lawful permanent resident is a life-changing opportunity that opens the door to stability, career growth, family security, and eventually U.S. citizenship. In this complete guide, I will explain everything you need to know about how to get a U.S. Green Card in 2026, including the main eligibility categories, step-by-step application processes, required forms, costs, timelines, interviews, common mistakes to avoid, and what happens after approval. If you are serious about moving to the United States permanently, this guide will give you a clear roadmap. Let's begin with the basics. A green card holder is officially called a lawful permanent resident. This status allows you to live anywhere in the United States, work for almost any employer, own property, attend school, and receive certain legal protections under U.S. law. However, it does not give you the right to vote in federal elections or hold certain government positions. After maintaining permanent resident status for a required period, usually 5 years or 3 years if married to a U.S. citizen, you may apply for U.S. citizenship through naturalization. There are several main ways to get a green card. The most common categories include family-based green cards, employment-based green cards, the diversity visa lottery, refugee or asylum status, special immigrant categories, and humanitarian programs. Each category has its own rules, processing times, and requirements. Let's first discuss family-based green cards, which are one of the most common paths. U.S. immigration law allows U.S. citizens and lawful permanent residents to sponsor certain family members for permanent residence. Immediate relatives of U.S. citizens have the fastest processing because there is no annual visa limit for them. Immediate relatives include spouses of U.S. citizens, unmarried children under 21 of U.S. citizens, and parents of U.S. citizens if the citizen is at least 21 years old. Other family members fall under preference categories, which have annual limits and waiting lists. These include unmarried adult children of U.S. citizens, spouses and unmarried children of green card holders, married children of U.S. citizens, and siblings of U.S. citizens. The process usually begins when the U.S. citizen or green card holder files Form I-130, Petition for Alien Relative, with U.S. Citizenship and Immigration Services, also known as USCIS. Once the petition is approved and a visa number becomes available, the beneficiary can either apply for adjustment of status inside the United States using Form I-485 or go through consular processing at a U.S. embassy or consulate abroad. Marriage-based green cards are very common, but they are also closely examined to prevent fraud. The couple must prove that the marriage is genuine and not entered into solely for immigration benefits. Evidence can include joint bank accounts, lease agreements, photographs, communication records, and affidavits from friends and family. Most couples must attend an in-person interview where an immigration officer asks questions about their relationship. If the marriage is less than 2 years old at the time of approval, the green card will be conditional and valid for 2 years. Before it expires, the couple must file Form I-751 to remove conditions and prove the marriage is still real. Now let's move to employment-based green cards. These are for individuals who have job offers in the United States or who possess extraordinary skills. There are 5 main employment-based preference categories known as EB1 through EB5. The EB1 category is for priority workers, including individuals with extraordinary ability in sciences, arts, education, business, or athletics, outstanding professors and researchers, and multinational executives or managers. The EB2 category is for professionals with advanced degrees or exceptional ability in their field. The EB3 category is for skilled workers, professionals, and certain other workers. The EB4 category covers special immigrants such as religious workers and certain employees of U.S. government organizations abroad. The EB5 category is for immigrant investors who invest a significant amount of capital in a U.S. business that creates jobs.
In most employment-based cases, the employer must first obtain labor certification from the Department of Labor through the PERM process.
This process proves that there are no qualified U.S. workers available for the position and that hiring a foreign worker will not negatively affect U.S. wages. After labor certification is approved, the employer files Form I-140, Immigrant Petition for Alien Worker. Once the priority date becomes current according to the visa bulletin, the applicant can file Form I-485 if inside the United States or apply through consular processing abroad. Some categories like EB-1 Extraordinary Ability and EB-2 National Interest Waiver allow self-petitioning without a job offer if the applicant can prove significant achievements and benefit to the United States. The Diversity Visa Lottery, often called the Green Card Lottery, is another pathway. Each year, the U.S. government makes up to 55,000 immigrant visas available to individuals from countries with historically low immigration rates to the United States. Applicants must meet education or work experience requirements and submit an online entry during the designated registration period, usually in the fall. Winners are selected randomly by computer. However, being selected does not guarantee a green card.
Winners must still pass background checks, submit documentation, attend an interview, and meet eligibility requirements.
The process must be completed within the fiscal year, or the opportunity is lost.
Refugees and asylees can also obtain green cards.
A refugee is someone who applies for protection from outside the United States due to persecution or fear of persecution based on race, religion, nationality, political opinion, or membership in a particular social group.
An asylee applies for protection from within the United States.
After 1 year of being granted refugee or asylum status, individuals can apply for permanent residence by filing Form I-485. Special immigrant categories include religious workers, certain Afghan and Iraqi nationals who assisted the U.S. government, certain international broadcasters, and juveniles who have been abused, neglected, or abandoned. Each of these categories has unique eligibility criteria and documentation requirements.
Now let's talk about adjustment of status versus consular processing.
Adjustment of status is for individuals who are already legally present in the United States and eligible to apply for permanent residence without leaving the country. This involves filing Form I-485 along with supporting documents such as medical examination results, proof of financial support, and identity documents. Applicants may also apply for work authorization and advance parole while waiting for approval. Consular processing is for individuals outside the United States or those who are not eligible to adjust status. After the immigrant petition is approved and the visa number is available, the case is sent to the National Visa Center. The applicant submits fees, civil documents, and an affidavit of support before attending an interview at a U.S. embassy or consulate. If approved, the applicant receives an immigrant visa to travel to the United States and becomes a permanent resident upon entry. One critical concept in employment and family preference categories is the priority date. The priority date is generally the date when the immigrant petition was filed. Because of annual limits, especially for applicants from high-demand countries, there can be long waiting periods. The U.S. Department of State publishes a monthly visa bulletin that shows which priority dates are currently being processed. Applicants must monitor this bulletin carefully. Costs for a green card vary depending on the category and location. Fees may include petition filing fees, adjustment of status fees, biometric fees, medical exam costs, translation fees, and attorney fees if applicable. It is important to review the most recent fee schedule on the official USCIS website before applying.
The medical examination is another key requirement. Applicants must undergo a medical exam by a USCIS designated civil surgeon in the United States or an approved panel physician abroad.
The doctor checks for certain communicable diseases, vaccination compliance, and other health conditions. Failure to complete required vaccinations can delay approval. The green card interview is often the final step.
During the interview, an immigration officer reviews the application, verifies documents, and asks questions to confirm eligibility. For marriage-based cases, questions may focus on the relationship. For employment-based cases, questions may focus on job qualifications and employment details. Honesty is critical. Providing false information can lead to denial and potential immigration consequences. After approval, the applicant becomes a lawful permanent resident and receives the green card by mail. Permanent residents must carry proof of status and renew the card every 10 years. However, status does not expire with the card itself, only the physical card needs renewal. Conditional residents must remove conditions before the 2-year card expires. Maintaining permanent resident status requires following certain rules. Permanent residents should not remain outside the United States for extended periods without proper documentation. Trips longer than 6 months may raise questions about abandonment of residency, and trips longer than 1 year usually require a re-entry permit obtained before departure. Permanent residents must also file U.S. tax returns as residents and obey all laws. Certain criminal convictions can result in removal proceedings. Many permanent residents aim to